Morning, my name is Olive Mugenda. Welcome.
Thank you and good morning.
Good morning, Mohammed Warsame, welcome.
Thank you. Good morning.
Yes, thank you, Honorable Commissioners, for that introduction. Council, you can start by telling us your county and your ethnicity.
Thank you. My county is Nairobi and my ethnicity is Kenyan Asian. That's the 44th tribe of Kenya.
Yes, we have read your CV and received your original certificates. I think it's the first time we are receiving framed copies. The commissioners will ask you more questions during the interaction. But you can briefly tell us about yourself, your background, academic, professional qualifications, what motivated you to apply for this position. We know you are coming from private practice and you also teach at the Strathmore. So what are you really looking for in this position, and what value will you add to it? And please remember to highlight some of the key achievements that you have made in your career that relates to this position.
Thank you very much, Honorable Chief Justice. I really do believe that this is my calling and one that I must answer to. For as long as I can remember, I have always wanted to serve the public as a judge. For a person of my training, it is the highest honor to be able to serve society in a way that can make a real difference towards ensuring that the values that we treasure as a society, such as our fundamental rights and freedoms, peace, order, and good governance, are maintained. I also have a personal sense of civic responsibility, and I believe that we as a society have a shared responsibility to ensure that our values as a republic and enshrined in our Constitution endure and are passed on to the next generation. And I believe that a judge plays a fundamental role in carrying out that particular duty. Additionally, as an academic, as an arbitrator and a practitioner, I really would enjoy the work. I enjoy research, I enjoy writing, and I enjoy constantly updating my knowledge. And I hope that in time I will be able to contribute to our expanding indigenous jurisprudence. I'm also deeply committed to public service. I grew up understanding that it is a privilege to serve society, one that is held as a public trust, and I'm passionate about the justice system. It would be fulfilling for me to devote my life to a career working with the law and for the law in service to our society. With regard to my experience that is relevant for this position, the starting point is that I'm an advocate of 13 years experience at present. I'm also a law lecturer and I'm also an arbitrator. The key skills that I have developed, broadly speaking, that are relevant to this position are good organizational skills, good time management skills, good case management skills, and good interpersonal and leadership skills. And I will share a few examples as I highlight my work experience. I'll start with my educational background. I have a master's degree from the University of London, School of Oriental and African Studies, where I graduated with distinction. The focus of my studies was justice, reconciliation, and rehabilitation in post-conflict societies, law and governance, and law and development, and international commercial arbitration. I also have a LLB from the University of Kent, where I graduated with an upper second. Additionally, I have a BA from the University of McGill, Canada, where I graduated in political science and international development. Additionally, I have professional qualifications, including the lawyer licensing exam in the UK, known as the LPC, and I was also called to the bar in Canada as a barrister and solicitor. With regard to my experience that is relevant and suitable to this position, I began my early life and career at Hamilton Harrison and Matthews, where I did pupillage. Thereafter, I briefly worked for the United Nations Children's Fund, UNICEF, Kenya. My role at UNICEF Kenya initially involved working with the private sector in order to mobilize resources to enhance the rights of vulnerable and marginalized women and children, specifically towards programs for maternal health and newborn care. Thereafter, I helped to set up an emergency communication center, and the purpose was to link the national government to the various counties in order to combat waterborne diseases that were affecting people's rights to access clean water and to live with dignity. The key skills that I developed while working at UNICEF were, firstly, I learned to develop relationships with partners and stakeholders. Secondly, I learned how to fundraise, resource mobilize. Thirdly, I learned to train county officers, and I learned to help teach them preparedness plans known as SMART plans. The balance of my career has thereafter been in private practice, and I will summarize my experience across various law firms. My experience in private practice ranges from dispute resolution, including litigation, arbitration, and mediation, to general advisory in areas such as commercial transactions, as well as family-related disputes and real estate law and some employment-related issues. I've appeared in various courts across various counties in Kenya, and I presently have ongoing matters in both the High Court and the Court of Appeal. I've also had the opportunity to serve as a resource person in several constitutional tribunals while carrying out my practice, and I've had occasion to do pro bono criminal appeals. The key skills that I have developed while in private practice are primarily the ability to manage my workload and manage my time in a way that I'm able to carry out multiple different activities while running my practice. Those activities have been teaching as a lecturer at Strathmore, teaching at the Chartered Institute of Arbitrators, as well as sitting on numerous other boards and committees while running my practice. In addition, I have also learned to manage clients and client expectations, and I believe that the combination of these skills will translate into good case management skills as a judge. Similarly, if selected as a judge, I will take the time to organize my files and manage my time. I will look to identify files that may have become dead, where the parties are no longer interested in the litigation. I will deal with them appropriately, perhaps by way of Order 17. I will also take time to identify files that may be suitable for allocation to mediation, and I will have them allocated so that we can reduce case backlog. Finally, I will take time to identify the older files so that I can deal with them as a matter of priority. All this I hope to do with a presiding judge, if there is one, with a view that every matter filed before me will be heard and determined within 3 years, as per the vision of STAJ. In addition to my experience in private practice, I also have experience as an arbitrator. My experience as an arbitrator has brought me the rank of Fellow at the Chartered Institute of Arbitrators, and the key skills that I have developed as an arbitrator are, firstly, good drafting skills. I've learned to draft awards, rulings, and orders for directions. I've also developed good case management skills, and those case management skills in an arbitration are carried out from the outset at the preliminary meeting all the way and up to the pre-trial hearing, and I also teach those skills. Additionally, as an arbitrator, I've developed quasi-judicial skills, the ability to prefer the evidence of one party over another, the ability to frame issues appropriately, and the ability to weigh evidence. Additionally, I have experience as a law lecturer, and my experience as a law lecturer is at Strathmore as well as several professional institutions, including the Chartered Institute of Arbitrators and the International Chamber of Commerce Arbitration Commission for Kenya. I taught and developed the first arbitration course at Strathmore. It's a popular course. To give you an idea, most electives have 30 to 40 students. My last class had 110. The key skills I have developed as a law lecturer are, firstly, I have learned to improve my writing and my research and stay abreast of developments in law. Secondly, I've learned to manage my time. To give you an idea, I marked 110 scripts last semester while supervising dissertations all year round and managing my practice. Finally, I've developed certain soft skills, such as empathy for students with difficulties, and being able to treat and mark students equally and fairly. Finally, I have public service experience, and I'll briefly highlight it and then come to an end. My public service roles include being the present chairman of the International Chamber of Commerce Arbitration Commission for Kenya, sitting on the Chartered Institute of Arbitrators Education Committee, sitting on the Nairobi Center for International Arbitration Editorial Board, and being a chairman of the Nominations Commission for ICC Kenya. The skills that I've developed here, I will briefly say, are leadership skills. I've learned to develop collegiality within my commission. And I have fostered a leadership style that are based on democratic principles of inclusivity and merit-based criteria in our nominations. Finally, I've developed a personal approach that is based on treating people with courtesy and indignity in all I do, and I will carry this mindset into the judiciary if selected.
Thank you. Thank you very much for that very elaborate personal statement that shows what you have done as a young man. I believe the commissioners will have other questions to ask you following that. So we will go straight into the technical area of the interview, and I will take you to chapter 6 of the Constitution on leadership and integrity, and ask you to tell me about 5 key principles of leadership and integrity that will govern you or inform you if you are successful in this venture of being nominated as a judge.
Thank you very much, Honorable Chief Justice. Leadership and integrity, I think, is absolutely vital for a judge, and we have responsibilities of leadership that are set out in our Constitution at Article 73. Those responsibilities mean that we must first of all protect the purpose, and we must protect the values and principles of the Constitution. It means that we must treat people in a way that brings dignity to the office. It means that we should carry out our duties with honesty. We should carry them out in an accountable way. And there are guiding principles in Chapter 6 which says that we must disclose any conflicts of interest. We must have a selfless service that is based on the responsibility to serve the people rather than the power to rule over them. My understanding of these provisions is that we as judges essentially are serving people. We are not ruling them. There are many further provisions that have been given effect in terms of Chapter 6, in terms of the Leadership and Integrity Act, in terms of the Judicial Service Code of Conduct 2020, which outlines as well many of our responsibilities as leaders.
I'm happy with that. So now that you have been an arbitrator, and that is one area we are really focusing on in the judiciary. And you mentioned the stage, which is heavy on multi-door approach as an avenue for ensuring access to justice to more people. So Section 35 of the Arbitration Act allows an application to be made in the High Court. I want you to tell the commissioners the circumstances under which the High Court can set aside an arbitral award.
Thank you, Honorable Chief Justice. Section 35 is a very narrow and limited section upon which an award can be set aside. The basis of doing that is whether there was some sort of incompetence or incapacity in terms of the party or one of the parties, whether there was no notice made in terms of the appointment of the arbitrator, whether the matter is not arbitrable, meaning capable of settlement by way of arbitration. In addition, there is a jurisdictional element, whether or not the scope of the agreement was beyond, or rather the award went beyond the scope of the agreement. So an arbitrator has made a decision that is beyond his jurisdiction to actually make such a ruling. Additional qualifications that allow setting aside are whether the agreement was based on some sort of illegality, whether it was induced by fraud, perhaps the award is against public policy. So all of those are different grounds for setting aside, including composition, that the composition of the tribunal was not in accordance with the agreement of the parties.
And what is the emerging jurisprudence from the Supreme Court on whether a decision of the High Court to set aside an arbitral award is appealable to the Court of Appeal or even to the Supreme Court.
Thank you, Honorable Chief Justice. The most recent case on that was the Newto case. And in the Newto case, the Supreme Court said that there is a limited and very circumscribed appeal from the High Court to the Court of Appeal. And that narrow and limited approach is for the Court of Appeal to ensure that the High Court did not go wrong in its application of Section 35. And if it did go wrong, it must have gone so wrong that it closed the doors to justice. And it was a manifest and grave error on the part of the High Court. So those are the only grounds upon which the Court of Appeal will revisit an award that has been set aside by the High Court.
From the Institute, because you also occupy a senior leadership position at the leadership of the Institute of Arbitrators, and also as an academic, and this is the area you teach. Do you agree with this reasoning?
I do agree wholeheartedly. The Chartered Institute of Arbitrators were actually amicus curiae in that matter. They participated in it. And I think the reason that it's very important that there is a limited appeal is because parties should not be denied access to justice in the event of an actual error made on behalf of a judge. There must be some ability to review, even if based on limited grounds. So I completely agree with the decision of the Supreme Court.
Especially when the decision is manifestly wrong.
Absolutely.
Yeah, thank you very much. The next set of questions will be asked by Commissioner Macharia.
Okay, just 2 questions, Alim. I'll not ask you about being distinguished, because a lawyer or an academic must be distinguished for them to qualify. I believe from what you've narrated, you're actually distinguished. Now, but I'm just wondering, say you become a judge tomorrow, and the Chief Justice decides you're being posted to, the next day you're being posted, say, to Garsen or Migori or wherever. Would you tell this commission whether you manage? You know, we have children who we've brought up in a way that they are a bit soft. So I was just actually reflecting and asking myself whether my son or my daughter, if they are employed in public service and they are posted in some of the areas, whether they'll manage. I'm asking this, in good faith. I don't know. What would be your response to that?
Thank you, Honorable Commissioner. I would wholeheartedly go wherever it is that I am posted. In my practice, while at UNICEF, I actually went to many different counties and carried out work in different counties at different levels, including primary schools in different villages. I have no problem whatsoever in going wherever I'm posted by this Honorable Commission.
Yeah. Then my final question, in your interaction with the judiciary, what are the 2 challenges that you've encountered that you think that if you became a judge, you would ensure that you do things differently so that you're able to address those challenges?
Thank you, Honorable Commissioner. I think the first one is that we have significant delays in rulings. And I think that we as judges have to manage our caseload, manage our time in a way that we can actually deliver on the date that we set for parties. I would make it a priority to manage my case as well so that I'm able to do that. Another problem that I think I have faced personally was a situation where I appeared before a judge on a date that I was given, and unfortunately our documents were not on record, despite having been filed on the e-filing system and despite having been emailed to the individual supporting the judge in that particular matter. So when we arrived to highlight, we had to take a new date. When we took a new date, again, the documents were not on record. So I think there may be a practical fix to this. It turned out that the emails were bouncing. They were too full. There wasn't enough storage space. And so what was happening is that the judge was having to use multiple emails belonging to other people in order to receive all the documents that she required. I think the practical fix is that as an institution we can allocate a little more resources, we can buy more data, we can buy more storage space. If need be, I think I would buy my own extra storage space just to ensure that I have space for my documents, and we can check with the people supporting us before a matter comes up that all the documents are there, that we have seen them and we're ready to proceed. So that's a small practical fix, but an example of something that can cause delay.
All right, thank you very much. I wish you well.
Thank you.
CJ Wakili, in sexual offenses, especially offenses against minors, there is need for corroboration. How do you establish, other than evidence presented by parties, corroboration?
Thank you, my lord. In sexual offenses, I think the starting position is that the evidence of a single witness, if that is the victim, is okay, so long as that evidence is credible. And I think the idea is to ensure that the victim has provided you with a clear account of what happened, they have given you all the circumstances of what took place on the date, and that you are actually convinced that their evidence alone is sufficient. What you might want to think about is, for example, whether or not the lighting conditions were sufficient at the time, whether or not the victim reported the matter to the police immediately after. If it wasn't immediately after, how much time had passed by. You could look at some of the practical elements to find out if that single witness and only that evidence of that individual will suffice.
Okay,
But you can convict, I think.
Okay, you need to look at it properly. Secondly, there are certain rights given to accused person under section 200 of the CPC before a case proceeds before another magistrate, a new magistrate who has taken the evidence. There are certain requirements which the magistrate must comply with, and there are certain rights that must be accorded to the accused person. Tell us the rights that must be accorded to the accused person.
Thank you, my lord. The rights that I think an accused person must be afforded in the event that you've mentioned is they should be entitled to adequate time to prepare their defense if they need it. They should be entitled to re-cross-examine any of the witnesses that appeared. They should be entitled to essentially all the safeguards of a fair trial, given that this matter is proceeding before a new judicial officer. So if that means that they have to start a de novo trial, they should even be given that opportunity to do so.
Okay. God willing, if you get the opportunity, you'll be dealing with the issue of the burden of proof and the standard of proof. Tell us what is burden of proof is concerned with, and what is the standard of proof in election matters concerned with.
Thank you. In an election matter, the standard of proof is between the balance of probability and between beyond reasonable doubt. So it is between the two. It lies halfway. The legal burden is always, the legal burden is always on the petitioner. He who alleges must prove. And that evidential burden or legal burden remains with the petitioner, but the evidential burden may actually shift depending on whether the other side needs to provide an answer that is reasonable to evidence that has been proved by one side. So an evidential burden can shift back and forth, but the legal burden remains with the petitioner. The standard of proof, as I said, is between the balance of probability and beyond reasonable doubt in election petitions.
Thank you very much. I wish you well.
Thank you.
Honorable Inji.
Just one question. Just on the matters of interpretation of the Constitution, can you give us at least 3 principles or tests that will be applied by the courts in determining whether or not a statute or provisions in a statutes are unconstitutional?
Thank you, Honorable AG. The tests in relation to whether or not a statute fails the test of constitutionalism in human rights matters are actually found in Article 24. And essentially, we have to look at what was the purpose of the limitation, if it has been set out in law. What was the extent of that limitation? Were there less restrictive means available to that limitation? Has the limitation derogated from the core fundamental right of freedom? And sometimes we call this the proportionality test, sometimes we call it a rationality test. We have to look at the connection between the limitation and the purpose of the limitation. So those are some of the tests that we would carry out. But there have been new tests that have been introduced. And for example, in the recent CDF case, the Supreme Court created a new test. They created a test as to whether or not one arm of government has strayed into the core mandate of another arm of government, and in doing so they have violated the national principles and values enunciated in Article 10. So that test relates to the separation of powers and is actually new case law for us.
Very well.
Thank you very much, Justice Majanja.
Thank you, Your Honor, and good morning.
Good morning.
A few questions from me. On the day you are appointed, you are taken to Migori town, and on the first day you have 10 murder cases fixed for hearing. You call out the first one, the prosecution witnesses are not available. You call out the second one, the doctor who was coming on that day is not available. You call out the third one, the handwriting expert who was supposed to come and testify is not available. You call out the fourth one, the chief puts up his hand and says the family of the victim would have liked to attend the court, but they are not available. Nevertheless, all the witnesses are available, and you are ready to proceed. Tell us from a practical point of view, how would you deal with those situations?
Thank you, my lord. So I think the last one, where the family would like to attend but were not available, I don't think that's a good enough ground to not proceed. So that one absolutely I think must proceed, because the case belongs to the DPP, not to the family. And I think that it is the DPP's decision to prosecute, so it must continue irrespective of whether the family are able to watch or not. But I would note their preference.
Okay.
The other...
Yes, before we... So, have you familiarized yourself with victims' rights?
Yes, I have with the Victims Protection Act, and I know that victims have a right to take part in the trial, especially when there are matters that affect them, and especially where any decisions are being made. They provide context and they clarify. But my understanding was that this is not the victim, but the victim's family that would have liked
The victim, these are murder trials, so of course the victim is dead.
I stand
So-
guided. I stand guided, my lord.
So
You're absolutely
is
right.
the family not the victim in this case?
The family is the victim in this case, and I stand guided, you're right. I think given that victims and their families in this sort of situation have a right to participate in the trial, they have a right to provide us with clarifications and content so that we understand how they were hurt and what occurred. I will revise that answer and say that yes, they have a right to participate.
So, so it turns out that this is a murder case that has been going on for 10 years. The accused says, I have been in custody for so long, we must proceed. What would be your reaction?
So one of the principles is that in criminal matters you don't adjourn beyond 15 days, especially when the accused is in custody. So generally speaking, any adjournment must be within that 15-day period if required. The other point is that we don't want to hold people or remand them in custody while trials go on forever, because it's simply not fair to the accused.
Okay, go to the other cases.
In terms of the other cases,
The handwriting expert.
the handwriting expert, I think, is a pretty crucial witness. We would want to have their evidence, especially if it revolves issues of contestation around the handwriting. If the handwriting is critical to the issue, I would want to see and hear from the handwriting expert.
So if, looking at the record, you find that the handwriting expert has been summoned 3 or 4 times and he has never come, what would you do about it?
Well, I could summon him to court and sanction him with costs, or her with costs.
But you've been summoning him, you've looked at the record, 3-4 times. You've summoned, he has not come. The second time you summoned, your predecessor judge summoned, they didn't come. Third time summoned, they didn't come. So now it is your turn. Again, you just summon and they don't come, or what do you do?
I think we can urge the DPP to consider getting an alternative handwriting expert if that evidence is crucial, and perhaps even sanction the DPP with costs in such a scenario, because we are losing valuable judicial time if that's been the situation.
What is the ultimate sanction for
The ultimate sanction, by and large,
non-attendance?
for non-attendance, the ultimate sanction would be commitment to commit them to civil jail. But I would do that very cautiously.
But he's not attended 4 times, so what caution is there?
So I think before doing something like that, unfortunately, I would want to hear from him as to why he can't attend, but that's difficult if he's not attending.
So what do you do
it's difficult to get the reasons.
to enforce his attendance? What do you do?
I think at this point I would go with costs, because I don't want to commit someone to civil jail without having an opportunity to hear from them as to why they're not showing up and what the reasons are.
Okay, maybe you would consider issuing a warrant of arrest so that it's brought to you to show cause.
Thank you.
Okay.
Thank you.
The doctor?
The doctor, again, I'm assuming that the evidence of the doctor would be critical to this particular murder trial. I would find out why the doctor was unable to attend, ask for the reasons, and standing by what you said previously, I would issue a warrant of arrest to have the doctor appear if he has been doing the same thing as the handwriting
Now you're
expert.
told the doctor is involved in an operation at the hospital this morning. What would you then do?
That's a fairly good reason to me for him not being able to attend.
Okay, and the first one?
The first one, please remind me, it's a witness. In
The
what
witnesses,
capacity?
there are no witnesses. Who
There are no
attended.
witnesses. I think if there are no witnesses whatsoever, and that's been the trend, then in such a situation, the likelihood is that that case cannot proceed, and perhaps even should not proceed if the witnesses are not appearing repeatedly.
So you see now, you've had 4 cases. None of them have proceeded on that day. Outside the judicial process, are there any other processes you'd use to resolve? Because you've looked at the files, you noticed the doctor is not coming, has not been coming, handwriting expert has not been coming, witnesses have not been attending, victims are not attending. What other intervention would you make within the framework of the judiciary?
So outside of the courtroom, I believe there is interinstitutional discussion and committee which takes place, for example, in the NCAJ. And
Now you're in Migori. What institution is there?
so I don't know if Migori has an equivalent, but I think there's definitely room for interinstitutional participation and dialogue so that we can share situations, problems we have, and find resolutions around them, bringing stakeholders together in the interest of justice.
What is that body called? The body that brings together the stakeholders.
The body that brings the
At the
National
local
Council
level.
for
At the
Administration
local
of Justice.
level?
At the local level. In Migori, in
In
particular.
Migori, say in Migori or Nyeri or whatever.
Court user committees?
Yes, court users
Court
committee.
user committees, yeah.
So what would you do with the court users committee?
So at that court user committee, we could bring up this issue and have a discussion and find out what's going on and try and resolve it.
Okay, thank you very much. And finally, the same morning, an accused has been brought to plead to murder. Just tell me 3 things you'd look out for before you take the plea.
Thank you. I want to first make sure that the accused understands the language. I want to make sure that I explain the elements of the offense to the accused. I want to make sure that the prosecution has explained all the facts surrounding the offense.
Well, you haven't taken the plea yet. You haven't taken the plea. The accused has been brought. What would you look out for?
I'm looking at the accused in terms of his physical appearance. I want to see if he has any injuries. I also would want to look at his demeanor and perhaps see whether or not he has any mental conditions or whether or not he is of sound mind. There was a recent Court of Appeal decision that said a High Court judge must place an inquiry upon himself if it appears to him that someone who is before him may not be of sound mind. So I would want to consider that and look at his demeanor, look at his mental state, look at his physical
Okay.
condition.
Thank you. And finally, if he tells you I have been in police custody for 7 days, what would you do?
I would want to find out the reasons for his continuing detention and understand why he's been in police custody for 7 days. Is there a particular reason he has not been released on bail or bond?
Okay.
Perhaps he can make an application.
Is it him to make an application or you to make an order?
I can make the order, but I think I would need to be moved.
Despite the fact, thank you. Thank you.
Thank you. Commissioner Ngutia.
Thank you, Chair. Good morning once again, Council. I don't know why Commissioner Macharia and Majanja keep mentioning Migori as the most remote place. Have you been to Migori?
I have been to Migori, yes. on occasion.
And you can confirm it's a beautiful place.
It's a wonderful place.
And I know one of us grew up there. And he's doing so well. That's Judge Wasame. Okay, that was just on a light note. I have 2 questions for you. I see one of the work that you've done was with UNICEF on maternal health. The Constitution prohibits abortion, save for certain conditions. Kenyan government has issued reservations on Maputo Protocol with regards to reproductive health and not reproductive health generally, but abortion. But we have not issued any reservations to CEDAW, Convention on Elimination of All Forms of Discrimination Against Women. A matter then comes before you to determine the legality of abortion. How will you then rule in that case
Thank
in
you,
terms of
Honourable.
hierarchy of laws?
Thank you, Honourable Commissioner. I think the starting point is the Constitution. It's the supreme law of the country, which means that the only exceptions are the ones found in the Constitution, which is that the health of the mother is in danger or the life of the mother is in danger as certified by a trained healthcare professional. The Constitution does, however, say, and there's a small last word, or any other law, which means that the Constitution has given the people of Kenya the opportunity to make further laws and provide further exceptions if they so wish. That could be expanded in time through the relevant and correct bodies. So I think that at this point in time, the Constitution would be my guiding principle.
Thank you. So you've mentioned the Constitution being supreme, and then if you have any statute law, so where would you place the international conventions? For example, CEDAW. Below the Constitution, or below the statute, or after the statute?
Thank you, Honourable Commissioner. Article 2.5 of the Constitution says that the international laws, both customary and treaty, will apply in Kenya so long as they are not inconsistent with the Constitution or inconsistent with our laws. So as long as those are not inconsistent, I may look to them for guidance, I may look to them for clarity, I may look to them to breathe life into our provisions. And that is what the Supreme Court said in Mitumbel.
I'm satisfied with that answer. Judge Majanja was asking you a question with regards, asked you a question with regards to victim participation, and you have mentioned that the Victim Protection Act does provide for their participation in a criminal trial. So what happens when the DPP wants to withdraw charges and the victim insists that the matter should proceed? What do you do as a judge?
Thank you. The victim cannot usurp the role of the DPP. They play a part insofar as they provide clarity and context, insofar as what happened, and so that we can take into account their story. But the decision to either institute or withdraw prosecution remains with the DPP.
My last question, if you've been watching the videos, you know this is something I last asking about your judicial philosophy and whether it's in line with what the Constitution envisions.
Thank you, Honourable Commissioner. My judicial philosophy will be anchored in the Constitution, specifically in Article 259 of the Constitution, Article 10 and Article 20 of the Constitution. I will seek to do justice in a way that favors enforcement of our fundamental rights and freedoms and promotes the values of democracy and equality in a free and open society based on human dignity. I believe that Article 159 implores me to protect the purpose and values of the Constitution. So any judicial philosophy must first and foremost be rooted in the Constitution. And I think a recent example of that was the Supreme Court decision in the BBI case, where they said that the basic structure doctrine could not apply in Kenya for the simple reason that our Constitution already has provisions relating to amendment in Chapter 16. And if we were to import the basic structure doctrine, then our Constitution would not be speaking to those particular provisions. So our philosophy must first and foremost be rooted in the Constitution.
Okay, I'm satisfied with that. Sorry, I'd said last, but just looking at your sample writing, you write well, but I'm concerned why you chose 3 relating to the same matter. Does that mean you don't do other cases? Save for this party, I don't want to mention your clients here. Is it that they're your favorite clients, or?
Thank you. I thought they raised different issues of law, and I felt that they were relatively interesting pieces. That's the reason I chose them.
Thank you. Wishing you the very best. Thank you, Chair.
Thank you, Commissioner Gishohi.
Thank you, Madam Chair. Good morning.
Good morning.
I really appreciate your sentiment about commitment to public service, public trust, which is good. As a public officer, I would welcome you to join the public service as a judge, and I hope you succeed. Now, for us to do that, I want you to focus on Article 232, which is more or less our horizon, our beacon. And there are around 7 values and principles that are very dear to any public officer. And as a judge, you'll be a state officer. Would you share with us at least 4 of them?
Thank you, Honourable Commissioner. The 4 I will share is high standards of professional ethics, impartial provision of services, accountability for decision making, and transparency.
Okay. I want to take you to one which is you have not mentioned in terms of usage of public resources, management of public funds, which are very, very clear. And, as a judge, you might be sent to, I will not say Migori, I will say my hometown. You might be sent to Nyeri, which is my hometown, and you're in charge of resources there. Would you share with us 3 instruments, legal instruments, that guide you in terms of utilization and management of public funds? 3 of them.
Yes, Honourable Commissioner, I think one is the Public Procurement and Disposal Act.
Good.
I think the other one is the Public Finance Management Act.
Public Finance Management Act, yes.
And the third one, in relation to financial management, perhaps at my own court level, might be the, I think they call it IFMIS, the IFMIS system, understanding how that works.
No, that is under the Public Financial Management Act. These are statutes, these are acts of parliament, very specific, that every public officer should have them on their desk. I accept procurement, public finance. IFMIS is under public finance.
Right.
So I'm waiting for one last one.
At this point, a third one doesn't come to mind, but I will definitely look it up and make sure that I have it in front of me if the time comes.
It's Public Audit Act.
Thank you.
Very good.
Thank you, Honourable Commissioner.
Thank you very much, Professor Mugenda.
Thank you, CJ. I have 2 questions for you. The first one is about, I can see you've been a resource person for the tribunal that investigated 4 judges. Who appoints the resource people?
The resource people were appointed by the committee that was putting together the tribunal.
Okay. You must be good because you have done 4 of them.
Actually, it was because all 4 of the tribunals had the exact same team. So the resource people were kept on so they could continue to help the tribunals with their work.
Okay. All right. My other question is about what are some of the soft skills that are important for a judge?
Thank you, Honourable Commissioner. I think it's important for a judge to have empathy, and I think particularly emotional regulation, both of yourself as well as understanding that the people around you may be vulnerable, they may be traumatized, especially in family-related matters. So I think it's important to bear in mind that as you speak to the parties, they are also coming from a situation that may involve major trauma. So empathy, I think, and emotional regulation of yourself and managing those before you.
I think for the first time I've heard the word emotional regulation, and I'm very impressed. All the best.
Thank you very much, Commissioner Rwanda.
Thank you, my lady. Good morning once again.
Good morning.
Someone once said that the only thing worse than being talked about is not being talked about. I forget who it is. And I'm looking at the report we got on your background check. It doesn't yield much information. Yet I've listened to you this morning give us a brief on the background. And I'm wondering, why is that? Is it because despite doing all you have done, you have not made any impact out there? Or why is that?
Thank you, Honourable Commissioner. I feel I have made an impact, especially in the arbitration field. I've taught over 1,000 students to date, including professionals and students. So within the Chartered Institute and the Nairobi Center for International Arbitration, as well as the International Chamber of Commerce, there alone I've trained professionals and accredited them to carry out arbitrations. At the school level as well, I've been really making an effort to promote ADR pursuant to Article 159. I hope that the reason that people have not come forward will not be the same reason in the future, and that they will come forward and say good things. But I thank you, and I stand and I stand guided by you.
Okay. The other question I wanted to ask you is, you work at Strathmore University. That's where you lecture, and you also work in your own law firm. Yes. Do you have a performance measurement tool in either of those two institutions?
Thank you, Honourable Commissioner. The performance measurement tool that I utilize is an informal one. We don't have a documented tool, but because I'm a sole practitioner and I run my own firm, there's continuous feedback from my clients. What that means is that I'm in touch with them constantly, and it means that on a regular basis I pick their calls, I deliver according to the timelines, and there's continuous feedback. So it's really about managing my time and my resources in a way that has client satisfaction. Client satisfaction for me has been at the first point with the client.
And what about the rest of the staff in your law firm?
My law firm is a sole practice. I don't have other staff with me at present. We did before COVID, but since COVID, it has become a sole practice.
So you have no secretaries, you have no law clerks?
I do. I'm sorry, I have support staff. I thought you were referring to advocates. Again, because we're small, it's very informal. It's done on a more one-to-one scenario, regular discussions.
So as you sit here, you have, other than your award, you have nothing to show us to say that you are a good performer, either at the university or in your law firm. Most of the university.
Thank you, Honourable Commissioner. I think the testimonials and from people I've worked with will show that they have been very happy with my work, will show that they've considered my work with them to have been a valuable input in whatever we have done together. I think that if you were to speak to the dean at Strathmore, he would talk about what I do in my class and how much the students are benefiting from it. So I think there's definitely value. It's just that I don't have a formal performance evaluation like the judiciary does, but I've read about it, I understand it, I understand the markers of excellence and the parameters that we're looking for, and I wholeheartedly embrace performance management and measurement within the judiciary as a means to accountability and improved performance.
Okay. Now, do you have an account outside the country?
Yes, I do.
You do. So now if you did become a judge, what will be your obligation in respect to that account?
Honourable Commissioner, under the Judicial Service Code of Conduct, I'm supposed to seek permission from the JSC if I wish to continue operating that account. I'm also supposed to submit records, meaning the financial statements, if I wish to continue it. Alternatively, I can simply close it. But I would definitely seek this Commission's permission if I want to continue using it.
Okay. Okay, thank you. Do you engage in community service?
I do.
What do you do for community service to give back to society?
I give a lot of my time, so my community service has been predominantly in terms of giving time, and what that means is I sit on the Ismaili Legal Council Committee and I give pro bono advice. I have also given pro bono advice to other committees within the faith-based organization. I also supervise student dissertations all year round, even when I'm not paid for them, and that's part of my community service. I also mentor students. So it's more about giving my time, because I feel imparting knowledge sometimes is more important than money.
Oh, okay, thank you. I don't have any more questions to ask you. I've looked at your application. Your application is complete. I've already told you that we didn't get much information on you, but otherwise I wish you well.
Thank you, Honorable
Thank you, my
Commissioner.
lady.
Yeah. Thank you very much, Mr. Bislam, for that engaging interaction with you this morning. On behalf of the commissioners, I wish you well. We will get in touch with you when we complete the process. We encourage you to keep up the good energy that you are expending out there. But now, before we close, we'll also give you an opportunity to ask us a question.
Thank you, Honorable Chief Justice. I just want to thank the Commission for taking the time to interview me. I really appreciate this opportunity. Thank you all very much.
Thank you, and all the best. Have a good day.
Thank you.